Thank you for that flattering introduction. But most importantly, thank you for the warm welcome to the city of Hyderabad by all the three organizers of this today's talk. Of course, I'm particularly challenged, I would say, by the fact that we have members of Shaheen also here. But I believe that this kind of dialogue is very important. Some of my views may not be in consonance with theirs, but that's more the reason why I'm thankful to you and grateful to you for giving me this opportunity to present my own views. And I thought it was important for me to do this talk because I had represented collectives of Muslim women in the Supreme Court in the challenge to this case, and I have been asked many questions. Why did you go to court at all? Why did you raise constitutional issues? After all, the government of India was saying that triple talaq is unconstitutional, so they were the real champions of women's rights, and where was the need for you or others like you to go to court and argue this case? It's an important question which needs an answer. Now, in my opinion, the answer to this question goes back to what were the motives, or was there an agenda that the government had in taking this issue to court, if any? And it also raises the question, do women have agency to speak for themselves, or are they dependent on governments to speak for them? And in my mind and in the mind of many Muslim women, the answer was very clear. And they were there in large numbers to speak for and on their own behalf. They were very clear that no one can protect anybody's rights unless they stand up and protect their own rights. And I realized that this was a moment very different from 1989, when the Shah Banu judgment was delivered and there was a huge protest, and the government of India passed what they call the Muslim Women's Protection of Rights on Divorce Act. And in the name of protection of Muslim women, the rights that they were given by the Shah Banu judgment of getting maintenance under a secular law were actually taken away. But at that time, I did not see large numbers of Muslim women or organizations of Muslim women coming forward to challenge the government, or to give an alternative perspective, or to say this is what we believe to be our rights and this is what we do not believe to be our rights. Now, in contrast, in the year 2017, when this case was argued, let me tell you, the case was, the courtroom was flooded. Flooded is an understatement, by organizations of Muslim women speaking for and on their own behalf, all of whom unanimously argued that triple talaq had to go. For me, I would say in my lifetime, between 1989 and 2017, I saw this historic shift. I saw a historic shift of women who, between the period 1989 and 2017, had become very aware, had been standing on their own feet, had been speaking up for themselves, and they knew exactly what they were challenging. So, and let me tell you, shades of all opinions were reflected in court. It was not just my voice. I was arguing that triple talaq is unconstitutional, about which I'll say a little more later. But there were women, Bharatiya Muslim Mahila Andolan, many other organizations. Women said, we've got our own Muslim Personal Law Board. We don't need the All India Personal Muslim Law Board to speak on our behalf. they were arguing that triple talaq is un-Islamic. They did not say that triple talaq is unconstitutional. They said it was un-Islamic. So you had that one point of view reflected in court. Then there was the All India Muslim Law Board, Personal Law Board, and they said very clearly to the court, hands off Muslim personal law. You have no right to even question the validity of anything which is quote unquote personal laws. And you should just throw this petition out of court. We know what we are doing. We speak, we are the sole representatives of the voice of the Muslim community, including Muslim women, and we know what to do, when to do, and how to do it, and this is not a matter that the court should be talking about. I'm going to say a few words about that as well. And then there were voices such as mine. I was representing an organization called Vivak Collective and Center for Secular Studies, and we said, look, at the end of the day, we live under a constitution. We swear by this constitution. It governs every aspect of our life. What the court has to decide is whether something like triple talaq is unconstitutional. Why is it unconstitutional? Does it violate the right to equality? Does it violate the right to non-discrimination based on sex? And I was particularly keen on arguing that this case is not about Muslim personal law. It's a case about all so-called personal laws, whether it's Muslim, whether it's Hindu, whether it's Parsi, whether it's Christian. And the question for me was, are all these laws subject to the discipline of the Constitution of India? Or is personal law an island which cannot be touched by the Constitution of India? For me, this is a question that has remained unanswered by the court for the last 60, 70 years of its existence. And I found that the court was persistently unwilling to answer this question over this entire period of 50 years. I would like to give you the evidence for this statement that I'm making. Way back in the late 80s and early 90s, I argued Mary Roy's case in the Supreme Court. Many of you may be familiar with her name. She challenged a discriminatory Syrian Christian inheritance law, which said that on the death of the father, entire estate of the father will go to the son and only 5,000 rupees will be paid to the daughter. A very gutsy woman. She herself came out of a broken marriage. She went back to her home and she started living in her parental home. At that time, her brother turned around and told her, you have no right to live over here. All this that you see that was owned by my father now belongs to me. She took the case to court and she said, I will not believe that a daughter has no rights. I demand an equal right with my brother. Now, I was arguing her case, and what the Supreme Court did was, they said, all right, the law which was operating in Travancore and Cochin stands repealed after the coming into force of the Parsi States Act. In other words, they said, well, the erstwhile state of Travancore Cochin no longer exists, and therefore the law will not govern you, and you will be governed by the Indian Succession Act. Now, Mary got equal inheritance rights from this case, but the court did not answer the question whether personal laws were discriminatory, whether they violated the Constitution of India. So there has been a tendency in the Supreme Court of India to dodge this issue. I will come to the reasons a little later. They did not want to say up front that a law which says a daughter will inherit only 5,000 rupees is unconstitutional. The outcome of this case was a just outcome, but the reasoning of the case was unsatisfactory. After that, I got an opportunity to argue Geeta Hariharan's and Vandana Shiva's case. They, Geeta Hariharan wanted to make a deposit of 5,000 rupees in the name of her son in the Reserve Bank of India, and the Reserve Bank refused to accept that money. The bank said, "You are not the natural guardian of this child, we will not take money from you. Bring the father, and only then we will issue the bond in the name of the child, because he is quote unquote the natural guardian of the child." She of course refused. She said, "Rubbish, this is my self-earned money, my income, my earning. I want to give it to my son, and I don't care about your law which says the father is the natural guardian. I want to make this deposit." Then there was Vandana Shiva. She was also in a conflicted marriage, and her husband was claiming custody of her son. And her husband turned around and said, "I am the natural guardian of the son, so the custody should come to me." We challenged this law which said that a father is the natural guardian of the child. And the court once again gave a judgment which said, well, you know what the law says? The law says that the father is the natural guardian, but in the absence of the law, the mother is the guardian. So what we are going to say is that if the father neglects the children, then the mother becomes the natural guardian. Because the word after him was always interpreted to mean after the death of the father, the mother becomes the guardian. So they said, no, even during the lifetime of the father, the mother can be the guardian, but if the father neglects the children. Again, you can see they dodged a clearly discriminatory law. No, they don't want to answer the question whether these laws violate the Constitution of India. And then, of course, what happened in the Shah Banu case, all of you know, and how that judgment got reversed. So I came to the conclusion that the Supreme Court of India does not want to address the question of discrimination against women in relation to all personal laws. That's why I said right at the beginning, the question for me was not whether this is a challenge to Muslim personal law. The question for me was, is this a challenge to any law which discriminates against women? Article 14 and Article 15 are the two most important articles in the Constitution. Of course, Article 21 is equally important, the right to life and liberty. But these three, and 19, the right to freedom of speech, which today I think is very important. But we know that our Supreme Court has given judgments which say you can't just dissect a human being and say, oh, this is where your right to equality begins and it ends. This is where your right to life begins and ends. And this is where your right to non-discrimination begins and ends. This is where your right to freedom of speech begins and ends. They have said all your rights can be exercised simultaneously. They are indivisible. And so you have all these rights. You can't have one to the exclusion of the other. And yet, I'm noticing again and again that when it comes to women and family law, it's like hands off. And so, it makes you think, really, what is the reason behind this? And then you, of course, come to the conclusion that the reason behind it is the dominance of religion and its influence over family laws. This is where the arguments are coming from. And as the argument of the Muslim Personal Law Board was that for us it's a matter of faith. And we don't want any interference with our faith. Again, I repeat, this is not about Muslim law. Every single community argues that these matters for them are a matter of faith. These arguments were invoked at a time when sati was abolished, no doubt about it. Today I hear the same arguments amongst Hindus on the question of child marriage. No efforts are made to declare child marriage void. I want to give one more example, and that is the example of tribal women. In the Madhukeshwar case, the tribal law was challenged on the ground that a tribal woman who marries a non-tribal loses her right to inherit her father's property. This was challenged. Again, here the Supreme Court did something a little more sophisticated. What the Supreme Court said is, look here, we actually agree with you that this law is discriminatory, but this is not the job of the court to strike down a discriminatory law. We are going to leave this to a decision by Parliament. Now, what did the court do? The court actually abdicated its function to use Article 14 and 15 of the Constitution of India to do justice to women. All the examples I've given you are examples of cases which are on the face of it discriminatory against women. And yet, I would say that the Supreme Court of India just copped out, just opted out of its own function, of its own role. And something similar, of course, this is not the same issue, but it requires mention over here. Something similar happened when Section 377, which criminalizes homosexual activity, was challenged. The Delhi High Court upheld it. When it came to the Supreme Court said, no, 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 we have to exercise self-restraint and we have to allow Parliament to repeal this law. We cannot strike it down. So you have one High Court which is saying it's discriminatory, and you have the Supreme Court saying no, self-restraint. So again, the question comes to mind, why do you suddenly think of this self-restraint when it comes to the rights of women? Why do you think, is there some morality operating over here? Is it faith? Is it religion? What exactly is the roadblock to equality for women? Now, let me tell you, there have been judgments where the Supreme Court has said that the entry of constitutional law into family law is like allowing a bull to enter a china shop. A bull in a china shop. Now, for me, this statement is such a serious one. You're virtually telling women that in the realm of family law, the Constitution is not available to you. Leave family law out of any discussion on constitutional law. In other words, leave the right to equality out of any discussion on family law, which, I'm sorry, but as a lawyer or as a citizen, as a woman, I refuse to accept this proposition. We all read the Constitution of India, we all know the guarantees that are available to us, and we intend to exercise those guarantees in our favor. These are some of the considerations which led me to argue in the Supreme Court on behalf of the organizations that I mentioned to you earlier. Now, this is not the time and place for me to go into the various theories of what is triple talaq. A lot of you know what it is, but some of the interesting arguments and some of the judgments delivered by the court are enlightening. And let me tell you that these come from the British period. They come from judgments of the Privy Council of India. These are all pre-constitutional judgments. So the one judgment that the Muslim Personal Law Board relies on all the time is a judgment of the Privy Council, in which it was said triple talaq is bad in theology but good in law. Bad in theology but good in law. Now, none of us could make sense of this statement. We just couldn't understand it, you know. And I have to say that even the judges of the Supreme Court could not understand what was meant by this expression. And particularly one of the judges, Justice Kurian, of course, started laughing when this was mentioned. And he asked a direct question. He said, look here, if it's bad in theology, how can it be good in law? And you know, the Supreme Court of India, the then Chief Justice, Justice Kehar, had constituted what many of us called a quote-unquote multi-faith bench. Very funny. Under the Constitution, we are supposed to have, our judges don't have any religion, we have religion. We all have a religion, but when we are sitting on the bench of the Supreme Court, then we are sitting as constitutional courts. But we did have a multi-faith bench. And I've said, well, you had a multi-faith bench, but why didn't you have a multi-gender bench? There was no multi-gender bench, okay? So what did you have? You had one Muslim judge, one Sikh judge, one Christian judge, one Hindu judge, and it went on like that. And we were all supposed to be sitting there, and every time you address an argument, which is well, there was a strategy in operation when the arguments of the board were being presented. They would say things like, which would be appealing to a particular judge of a particular religion. And when they were opposing the intervention of the Constitution into family law, the lawyer for the board said, my lord, if you agree with her arguments, you know what will happen? Tomorrow you'll be told that Christians can't bury their dead. Now, this was an appeal to Justice Kurian, as if he's going to fall for that line. You know, you will be told that you can't bury your dead anymore, then all of us will have to do only one way of getting disposal of the dead. Because this is what she's arguing. Here am I trying to say, treat women with equality, and this man is talking about burying the dead. So, and it went on like that. Everybody was trying to appeal to the individual sentiments of individual judges belonging to a particular religious denomination. Not everybody, I mean the lawyer representing the board. And for me, of course, it was like I couldn't accept all these arguments, and I kept telling the judges again and again, let's come back to the Constitution of India, let's come back to the Constitution of India. And at one point I had to tell the judges, I said, see, as far as you know, there were discussions going on in court on the Quran for like a whole week. And there were people competing with each other who has the authentic English translation of the Quran. Every lawyer was saying, mine is the authentic version, his is not the authentic version. And it was being read and reread in court. And then I had to tell the judges, I said, look, excuse me, as far as I'm concerned, the Constitution of India is your Bible. You please come back to the Constitution of India and read it and make your own decision. Decide for yourself, you know. Don't look at 100 other documents. Just look at the Constitution of India and then you decide whether the claim of these women is right or wrong. And this is how the arguments were going on in court. And then, of course, at one point, the judges did something very interesting. When the Muslim Personal Law Board said that you want us to leave this issue to you, what will you do? So they said, you know what we're going to do? We are going to persuade the community to give up the issue of triple talaq and to give a talaq in some other way. So the court said, will you put it in writing? And they put it in writing. And of course, one of the things that they had to put in writing, because they were relying on the Quran again and again, they said, yes, it's true that the Quran also considers triple talaq sinful. Then you got the use of the word sinful in the affidavit. And for me, of course, I said, well, here is the answer to the question I've been raising. If something is considered sinful, can you consider it constitutional? Straight question. That was my straight question to the judge. Now you have it in writing from the Muslim Personal Law Board that triple talaq is considered sinful even amongst Muslim community by their own ulemas. So if they consider it sinful, are you then going to say that this is constitutional or dodge the issue? You have to answer the question, because the answer to the question would be relevant not only for Muslim women. As I said, the answer to this question would have been relevant for the country as a whole and for women as a whole. So we have to look a little bit into the origins of this system. And when you look at the origins of the system, you will understand that the system of governing Muslims by Muslim personal law, Hindus by Hindu personal law, Christians by Christian personal law originated with the British. Don't forget, all these laws are laws of 1939. And therefore, the question that arises for me is that, do we want to continue this system after the Constitution has come into force? And I said all the laws that were enacted before the Constitution came into force need to be scrutinized from the point of view of the Constitution. The British did have a policy of divide and rule. They did have their own reasons for, separating people on the basis of the religion to which they belong. But do we in the country also want to perpetuate this policy? And this brings me a little bit to the whole history of the development of Muslim personal law in India, and also to the politics of the situation, which I think law and politics are so completely mixed that whenever somebody raises a legal issue, you must ask yourself the question, in what political environment is this question being raised? Why is it being raised? Why is it that suddenly one day triple talaq becomes the biggest issue that the Supreme Court of India is debating? Okay, we had filed so many petitions, let's say on demonetization. They've all fallen through a black hole, but the triple talaq question was fast forwarded and put on the agenda. Why? Okay. And my only answer is because the government of India wanted it that way, not because Muslim women wanted it that way. And the woman who was ostensibly the person who brought the case to court, as soon as the judgment was delivered, she joined the BJP. Okay, so great. I mean, what, are we going to fall into that trap? Do we not know how to distinguish ourselves from all political parties and keep our heads firmly rooted in the Constitution? These are the considerations that compelled us to stand up there in court and say, look, this is unconstitutional. It's not about Muslim women, it's about Hindu women, it's about Christian women, it's about all women. This is what was the basis of my argument in court. And so it was an extremely serious challenge. In my opinion, it was one of the most serious challenges made to the Constitution itself. And that challenge came from women. Of course, I mean, there's sad to say that the question was not answered yet again. And the answer that the court gave was very interesting. We had 4 different judgments. Some of the judges said, yes, this is un-Islamic. And because it's un-Islamic, it is struck down. It does not belong to Indian law anymore. Again, you can see they didn't say it was unconstitutional. They didn't say it discriminated against women. Okay? And then they said, all right, but if a Muslim man wants a divorce, he can resort to some other form of divorce. He can say talaq, wait for 30 days, again say talaq, again wait for 30 days, try a reconciliation. If a reconciliation doesn't work, then it's a divorce. And I said, I'm sorry, but this is not acceptable to me. Why? Because you cannot have a unilateral talaq. And this is particularly poignant when it comes to Muslim law, because it's one of the only laws in the country dealing with marriage which unambiguously says it is a contract. It is a contract based on consent of 2 parties. So again, I raise the question, if it is a contract based on consent of 2 parties, how can one person dissolve that contract unilaterally? Even if it be after 3 months. How can you dissolve it unilaterally? I'm not willing to accept this proposition that you have to dissolve it unilaterally. Then I raised the question that all other forms of divorce, people, Hindus and Christians, we have to go to a court of law to get a divorce. Whether a woman wants it, whether a man wants it, they have to go to a court of law, and a secular court will decide whether the divorce should go through. I must make it very clear, I'm not someone who believes that there should be no divorce. I'm also not someone who believes that the law of divorce should not be liberalized. I personally believe that we should introduce a provision in our law for irretrievable breakdown of marriage, but I do believe that at the end of the day, a divorce must be granted by a court of law. A person who belongs to the secular system of justice delivery, a person who can look at it impartially and then give a judgment, yes, this is a case which should go for a divorce. Because why? Because divorce results very often for women in what I have called civil death. They stand to lose a lot. Which is not to say that women don't want to exit marriages, of course they do. A woman does want to exit a violent marriage, she does. But she doesn't want to exit a marriage with empty hands. That's not acceptable. And therefore, any law which deals with the question of divorce has to also deal with the question of distribution of the matrimonial assets at the time of dissolution of that marriage. Absent that kind of provision in any law, all laws are arbitrary. And let me come back again and tell you that that provision does not exist in any law in the country. Not for Hindus, not for Christians, not for Muslims. Perhaps there's one exception in the case of Goa, where there is a common civil code which is applicable across communities and which does provide for community of property on the breakdown of a marriage. And this, I think, is the challenge of our times. We need a law which deals with community of property. Now, of course, I'd like to deal a little bit with the argument on the other side, which is that these rights are protected by the right to freedom of religion. We are told that courts cannot interfere with Muslim personal law of marriage and divorce because they are protected by the right to freedom of religion. Now, this is where I have my biggest problem with the argument, because I ask the question whether marriage is a matter of religion or is it a secular, social, economic institution? And my answer is marriage is a matter of contract between two parties. Marriage is something that happens with consent. The form of your marriage might be in a church or through a nikah or with your saath feras, but that doesn't tell you what marriage is. You know, it's very interesting because I again challenged the court and I said, my lords, can you show me in any book or any text in India which tells you what a marriage is? You are told how to get married. You are told, yes, you can marry in a church. You are told you can marry in a temple. You are told you can marry with but what is the content of that marriage? Where is that? Where is that law which tells you that this is the content of the marriage? There's none. Absolutely none. And so I've been saying the laws in India, they tell you how to enter a marriage. They also tell you how to exit a marriage, but they really don't tell you what happens between the entry and the exit. There's a big silence over there, nothing. And then I gave my own definition. I said, well, according to me, and I've seen a few judgments which say marriage is a bond of love and affection between two people. It's a voluntary union between two people. This is how I understand what marriage is all about. And you're telling me marriage is about religion? No, it's not about religion. It's about a voluntary bond between two people who choose to have love and affection for each other and who choose to spend their lives with each other. So I said that you have to learn to distinguish matters of faith from matters of marriage. You have to learn to distinguish matters of faith from matters of what is the content of a marriage. And you have to understand that marriage is actually nothing other than a secular institution. And it does not mean that I'm trying to destroy the right to religion. I believe in the right to religion. I believe in the right to religion more so in today's context where the minorities in our countries are being really attacked through lynchings, through so-called vigilantism, through cow vigilantism, through banning beef. And in a million different ways, I'm arguing all these cases in the Supreme Court of India myself. I've challenged the beef ban from the Maharashtra law. I have challenged, I have represented people. Tushar Gandhi has filed a case in the Supreme Court of India calling upon the Supreme Court to decide how are these vigilantism deaths of the minority community going to be stopped. What does the Supreme Court of India have to say on this? All these petitions are going on in the Supreme Court. I'm also representing the widow of the person who was killed in Rajasthan by Shambulal, who beheaded a Muslim man in the name of quote unquote love jihad and put the video online. I've also represented Hadia and her right to marry the person of her choice. I rejected completely the argument that she has no right to convert. This is ridiculous. That's the right to freedom of religion. You have a right to convert to any religion you want to or profess any faith you want to. Nobody can tell you. And you have a Supreme Court which says we have the right to privacy, but what my religion is also my private business. You cannot tell me that I cannot be a Muslim or I cannot be a Hindu, I cannot be a Christian. That's my choice. But even though I recognize this right, at the same time, I do want equality for women. I feel very strongly about it, and I feel there's definitely a way in which we can harmonize the right to freedom of religion and the right to equality and exercise all these rights, as the Supreme Court has told us, without compromising either of them. And so I would like to really conclude now by saying that this is a battle for secularism for all of us. We cannot look at the issue of triple talaq in isolation. And we cannot allow the government of India to hijack this issue and say, we are the champions of Muslim women. What is the evidence of that? Now I come back to what I started with. Why did the government of India raise this issue in the first place? I think the real giveaway has come now. The real giveaway has come when they are introducing a law in Parliament, pushing it through the Lok Sabha, saying triple talaq is abolished. Well, what are you saying? The Supreme Court already abolished it. And then they say that it is a criminal offense. And anybody can be picked up for uttering the words talaq, talaq, talaq and put away in prison for 3 years. That, I think, was the hidden agenda of the government of India in arguing this case in court. Well, if they came to court and argued so vociferously that we are the defenders and champions of Muslim women, why have they not done that for Hindu women? Why have they not done it for Christian women? We are also governed by discriminatory laws. They have not done it. But they say, we and we alone are the champions of Muslim women. We reject that. They are not the champions of Muslim women. Muslim women can stand up for themselves and say, we are our own champions. And that's what this case was all about. This is what it was all about. Finally, I would like to say, and so of course, if they do pass this law criminalizing triple talaq, I'm afraid we will have yet another huge battle on our hands. That's also being peddled now as protecting Muslim women. Finally, of course, I'd like to end by saying that, in my opinion, it's time for us to demand that we recognize marriage as a civil contract for all communities. We do need a law in which we can say that every marriage is a civil union. Every marriage is a civil contract. And the consequences of the breakdown of that marriage must be spelled out by that law in terms as how will the rights of the women be protected? On a breakdown, how will the rights of the children be protected? I think that is the way forward for all of us. Thank you.
One issue that comes up is of individual rights. Why is it that neither the state nor the courts nor the civil society find it so important to really stand up for rights? Why have rights not got the same importance that it should in a democracy like ours?
I may not be able to give you a complete answer, but my own experience tells me that the extent of individuation in society, in Indian society, has not reached a stage where we actually believe in equality. Let me put it that way. That's one thing. Because if we did believe in equality, then we would know that everyone counts for one. I think we should begin to say the Constitution was written for one person. If you realize that every right in the Constitution is for one single individual, one single citizen, and we've not understood the concept of citizenship, that's the whole issue. That we don't see ourselves as citizens first before we see ourselves as which sex we belong to or which religion we belong to. That's part of the reason why you see that we are not able to understand the significance of rights, because I mean, you take the most fundamental of all, in my opinion, a very fundamental right, the right to speak. I mean, I would not be able to stand here and speak before you if I didn't have the fundamental right to speak. And in my opinion, that's one of the most endangered rights in the country today. I was telling somebody, last week I was on a show, India Today Conclave, with Rajdeep Sardesai, in fact, and I had to say at that meeting that the right to freedom of speech is so endangered. Everybody talks about it. An atmosphere of terror. Okay, the government can just cut off your advertisements to newspapers and say that, okay, we are not going to fund you anymore. We are not going to give you advertisements anymore. We are living in a country in which one person can ring up the editor of the newspaper and say, you will not publish this. Editors are being told today what headlines should be there on the front page of newspapers. And that is why I'm very thankful to you that you have given me this opportunity to come here and say what I want to say. If I didn't have this opportunity, where would we have this exchange of ideas?
You can keep that. Yeah, that's okay. Someone raised a hand here. Yeah. This gentleman in the white.
Madam, one question. Why is it that whenever we talk about uniform civil code, we only talk about amending the Muslim personal law, but we never talk about amending the Hindu personal law? Why is it always about Muslim? I mean, I'm sure there are a million problems in the Hindu personal law, but how is this articulation come up?
Yeah, it's again goes back to politics, because you're absolutely right, there are a million problems. I gave you only one of them. I told you about Gita Hariharan. I told you about Vandana Shiva. They were Hindus and they had problems with their laws. And so that the answer to your question is, there has been a debate in this country, or there has been an accusation made by the BJP against the Congress that they indulge in quote unquote appeasement of the Muslim community. And now recently the BJP has started calling the Congress a Muslim party. So what is the meaning of this? It means that we are bending over backwards to protect the rights of Muslims, and we are victimizing Hindus, okay? So this government set up a law commission to discuss the question of uniform civil code. So uniform civil code means all of us will have the same law, right? And the chairperson, Dr. Chauhan, a retired judge of the Supreme Court, gave a report saying, we cannot have a uniform civil code in this country. So my question would be, of course he's appointed by this government. So my question to Dr. Chauhan would be, Dr. Chauhan, when you say we can't have a uniform civil code, shall I say this is appeasement of the Hindus? How else am I going to see this? So that's the answer to your question. The question of uniform civil code is always politicized. It's never seen as an issue of gender justice.
Yeah. Yeah, that gentleman there. 1 minute. Avni?
Yes, sir. Good evening, ma'am. Question for you. Supreme Court says everyone to be transparent, but it itself is not transparent from its source. Right? From appointment of judges, etc. Don't you think Indian Judicial Service would solve that problem? An opinion on that. And the other thing is, it's not just overreach of judiciary, it's also the underreach of judiciary. It creates an arbitrariness in which issues judiciary shall go or shall not go. I would request your opinion on this. And next thing,
you have too many questions, too much. Okay, can I answer, please? Yeah. So anyway, I think you might have read some of my writings. Your question reflects that you read what I've been writing and what I've been saying. Please understand that I am the person who has filed a petition in the Supreme Court saying that the proceedings of the Supreme Court should be live streamed. I would like all of you to support this demand, right? You want to talk about transparency? Let's have it, okay? I think every one of you sitting here in Hyderabad and any other part of the country has a right to see what Ms. Jaising, maybe I've come here and told you lies. How do you know? How do you know that I argued what I told you I argued in the Supreme Court? Or that the Muslim Personal Law Board argued what they argued? You can turn around and say, no, this is not what they argued. What's the solution to the problem? The solution to the problem is live stream the proceedings of the Supreme Court in matters of constitutional importance. I'm not even saying that you video every single case, but let's look at it. When the Triple Talaq case was argued, all the arguments in court were simply brilliant. Even those who argued the other point of view argued very, very well. Even the Muslim Personal Law Board presented their arguments very well. And I only wish that there was a video or a record of the arguments that were presented in court. It would help all of you. You wouldn't have to invite me here for a meeting. You would just switch on to your television sets or to your phones and you would be able to listen to what's going on in court. So that's my answer to your question. Now, whether they'll do it or not, I don't know, because you look at what the Supreme Court is deciding. It's deciding Triple Talaq. It's deciding Aadhaar. It is deciding the right of women to enter the Sabrimala temple. It is deciding the right of a Parsi woman to attend the funeral of her father, which is being denied on the ground of personal laws. Now, it is deciding whether adultery should be struck down or not struck down. And so many other issues which are intimately connected with our lives. And that's why I believe that there should be this kind of transparency. And yes, on the question of appointment of judges, of course, a first step has been taken. They are now putting up their recommendations on the website. But I think you've missed the question. The real question is the government interfering with the appointment of judges? The answer is yes. Because Justice Joseph has been recommended for appointment of the Supreme Court. Is not being appointed, and the government is sitting on it, and the only reason is because he gave a judgment was sitting in Uttarakhand saying that President's rule that was declared was unconstitutional. So if this is how appointments are going to be made, we can't see justice.
This lady.
Welcome, ma'am, to Hyderabad. Myself, I am Dr. Asma Zahra. I am the head of the Women's Wing, All India Muslim Personal Law Board. And I appreciate your talk and welcome to Hyderabad. And I really appreciate the forum because this is a forum for public discourse. And I would like you to give me 2-3 minutes to present my viewpoint. What I was expecting from your speech was, at least in the last 10 minutes, if you could throw a light on the Triple Talaq Bill, that is the Muslim Women Protection of Rights on Marriage Bill 2017. See, the fundamental rights that Muslims enjoy, that was the thing that was argued, you have said, the Muslim Personal Law. Now, where the matter has become complicated is we have a very beautiful country where we have a Special Marriages Act. And the citizens of this country, even the Muslim women, are free to go for CRPC 125 or the Special Marriages Act. The personal laws are very sensitive to each community, and that is where the religious feelings flare up. And that is where there is a tug which you have said you could not understand in last 67 years. That is the thing, the personal law board thinks it is the domain where the judges should not or the Supreme Court should not. But the thing is, the Muslim Personal Law Board exercised restraint when this judgment was given, which was an interference in the personal law, which was a kind of, nullifying our right to freedom, right to our religious practice. But we did not protest when it was set aside. But after that, the worst part of this whole 4-year exercise on media debates and everything, when triple talaq is something very minimal percentage, and the board has assured that through societal correction and through a nikah and a contract, the social evil will be taken care of, there should be not meddling. Why did this bill come up, and it's such a draconian bill for which lakhs of women, Muslim women are protesting, and the entire women's rights issues, gender justice, everything has gone in the back foot.
Yeah.
Now this has totally taken up a very, polarizing stand. You're having rallies, lakhs of women attending a rally in Jaipur, Malegaon, Maharashtra, Nagpur, everywhere. You can see thousands of women protesting, saying take back the bill. So when we have a democracy, I would like you to, as a mediator, as a visual person, how this whole thing has been complicated, and how we can come out of this situation where something started with something with some very real good intention of women's rights, gender justice, but how it has ended up today,
Yeah. Okay, can I answer, please? Okay, two things. First of all, I most certainly appreciate, and I hope you will agree with me that in my entire presentation, I did say that the arguments of the Muslim Personal Law Board were very respectful, and that I myself, it was a pleasure for me to listen to the arguments of the Muslim Personal Law Board. What was the argument? The argument was the court should not interfere with Muslim personal law. Now, you and I can disagree on that, but we disagree in a civilized manner. Ultimately, it's for the court to decide. But the Muslim Personal Law Board also argued that it is up to the government to pass a law. Court should not interfere, but the government can if they want to interfere. And of course, they said the community can reform itself, no doubt about it. But they also said that the government has a right to pass a law. Now, they said, no, the Muslim Personal Law Board said, we don't dispute that the government of India has a right to pass a law, but the court has no right to interfere. Now, let's come back to after the judgment. Madam, I'm in full agreement with you that the judgment did not result in a protest. And that's why I did comment that this moment in history is very different from the Shah Banu moment. Please compare. I don't know whether you were there. I'm old enough to have been there when the Shah Banu judgment was delivered. I was present in court. I was seeing all the rallies. I was seeing all the protests. I know what happened at that time. Arif Muhammad Khan protested. He resigned as a minister, etc. We know the politics behind it. This time it didn't happen. And I'm glad, we are all glad that it didn't happen, because it prevented a kind of polarization. But I did say in my speech that I am also sad to see that the government has taken advantage of this judgment, and now they're doing what they want to do. They're demonizing a whole community. They're declaring a whole lot of people criminals. We have been shouting from the rooftop, what are you going to gain by putting men into prison? What will you get out of this? And are the women being benefited? Because I started by saying that we don't believe the government when they say that we are the champions of women. And the proof of that is this, that when we are all standing united and telling you that we don't want a criminal law, okay, you have declared it void, it's void. It's all right. But we don't want a criminal law. So please be very clear in your mind that many of us are united on this one single issue, that it should not be a criminal law. But you have to take care of your own community, madam. Within your community, there are women who are demanding criminalization, and you have to take care of those women. Your voices have to be heard louder.
Thank you, ma'am.
Keep it. Yeah, this gentleman.
Thank you for giving us this opportunity.
Little louder.
My name is Dr. Kadir Paja. I've done my law from Al-Azhar University, which is Islamic law and Egyptian law board. So with that background, I would like to ask you a very specific question. Coming to this triple talaq, because this was mainly on triple talaq. The verse that is in the Quran is very clear that there's no place for any multiple divorces. So whether it is twice or triple or 4 or 5, whatever. So the verse is actually that the divorce would be only a single divorce. That is the verse, and there's no other verse talking about a divorce in the Quran. And then there's also the requirement that a specific period should be there in which the divorce is given. So it's not haphazard. And then there's also the requirement that there should be 2 witnesses during divorce. That is part of the verse. But somehow in the Sunni Islamic law, that it has not been taken into consideration, the 2 witnesses. But the Shia law, they do take care of that. And any divorce would be in front of 2 witnesses. So that means that it should be a legal procedure going through the court. And this is why I think countries like Morocco, in which the law procedure is actually all taken place in a court. So it's not a place of, for example, in the home or anywhere where a man can give a divorce. My question is, to be very precise, triple divorce, according to the Quran, is illegal. According to Prophet Muhammad, illegal. All right. I don't want to go into details, but I could just mention this. So the question is, most of the countries, like for example Egypt, in 1925 they have abandoned this triple talaq. And what they're saying is, if a person pronounces more than 1 divorce, it would be considered as a single divorce. All right. So there's no issue of a triple or a double or anything like that. So if it is a single divorce, then why the penalty for the husband to that he has pronounced 3 divorces? That should not be there, am I right on this? So if we consider, if he pronounces 3, it's actually 1. So then there won't be any need to bring in a law to penalize the husband. Am I right on this issue or not? Thank you very much.
I agree. I must say that I'm not an expert on Islamic law, but all this was argued in court, and it was explained to court that there is nothing like triple talaq in Islamic law. It's actually instantaneous talaq. So the distinction that was made is between triple talaq and instantaneous talaq. And you're right in saying, if that instantaneous talaq is declared void in law, then what are you criminalizing? There is nothing left to criminalize. I can come back and again and again and again only to one issue. I think this government doesn't know what it's doing.
I can offer a supplementary here. I think that triple talaq is actually 1 talaq when it is effectuated on the last announcement of the 3rd series of 3. Still 1 talaq. Yeah.
In interreligious marriages, when the families are not in agreement with the marriage, most of the time they pressurize the spouse to convert the other into their religion. Which brings me to a subtlety of this matter. This conversion thing, most of the time the pressure is on the woman to convert when she marries a man of the other community. So while there is a right to religion, while there is a right to conversion, why is it? Did you question this basic premise? Why should a woman have to convert to marry a man of her choice from another faith? Why is that man expecting her to convert, to marry him? This is my question, because this to me is also about gender.
You're absolutely right, but I think there's only one answer in my opinion. Maybe I need to think about it more. But I did say, can we please separate religion from marriage? Is that something we're willing to take up as a national agenda? The answer to that cannot be that, oh, you can choose to marry under the Special Marriages Act. No, because many people just don't have that kind of choice. That there are pressures which operate on them to marry in a particular form, okay? Some say marry in church, some say marry with feras, but that cannot be determinative of what is the legal value of your marriage. The legal value of your marriage has to be secular. That's it. You can marry in any form you want to. I mean, it doesn't matter. You can have your destination marriage. You can go to Bangkok and get married. I'm not concerned. But the legal element of your marriage has to be a totally secular element. And in fact, I think what you say actually proves that women are being denied their right to religion, okay? It could be the man. I'm dealing with cases, you know, in Delhi there are very famous cases of honor killing where the man is killed. It's not only women who are being killed for marrying outside the community, even men are getting killed for marrying outside the community. So that deep-rooted casteist attitude, and I just want to remind you that I read, I'm sure Dr. Ambedkar, when he was talking about all these things, he said there's only one solution to end caste in this country, and that is intercaste marriages. But look how far we are from that in the country today.
See, marriage is a contract among Muslims, and as a secular country you felt that marriage has to be a contract for all of us. That would be very nice. But then when we look at Nikah-nama, we do sign, all the Muslim women who are here, they sign the Nikah-nama in which it is written that the woman has to obey her husband. It is written that she cannot go out unless he permits her to do that. She cannot call anybody home unless he agrees to that. So I think this contract has to be on equal footing. Gender equality in the contract is very important.
Yeah. Well.
But there is another question that I want to ask you, and Nikah-nama, which people are talking about, has to change. But what should be women's movement doing now when this triple talaq bill has come? Nobody is raising any voice.
No, ma'am, you're wrong. We are all raising our voices. I raised mine here, and all over the country, women are raising their voice against this.
At the time of marriage, you know, the woman can put in anything at the time of contract. See, I am an MBBS student. I have to continue my studies. I can put a contract. I have to finish off my studies. My parents are old. I don't have brothers. I can put a condition in the marriage. I will be taking care of my parents because I have my brothers abroad. So marriage is a contract, let me clarify. Any condition we
That
can
gentleman
put.
there.
Yes.
Good evening, madam. Madam, I'm an engineer and law passes over my head. So my question is, if me and my wife, we both want to have this type of talaq, and just we want to have this, and we are not destroying someone, we are not doing anything to someone. So why should someone tell us that it is not, why my right is, why are you not,
Okay.
and why violating my right? And also one question, madam, and one more question. You also told us that it is a contract, you can't dissolve it unilaterally. So if there's a contract for a road construction, so there is time involved, there's money involved and everything. So here, what are the basis of the contract? So why? There are live-in relationships today. So after a year, the girl moves out, taking her things. So why can't this happen like that?
How many questions? You better stop somewhere.
Madam, welcome to Hyderabad. I really appreciate your very passionate lecture on the topic. And I really thankful to Dr. Zahra. She has presented the standpoint of Muslim Personal Law Board and enlightened the people who are here. The thought came to my mind is the present regime is setting the agenda of discourse, and ultimately this discourse is being tracked by the regime. And we are discussing what regime wants us to discuss. We have ample of issues, we have hundreds of issues. So we are focusing on triple talaq, which is not the issue actually. Maybe someone get offended, but in reality, if you have a knowledge of what is going on in today's India, so I don't want to go into detail. But my question to you is, Madam Jaiswal, I saw you, I watched many of your debate on NDTV. I watch only NDTV, by the way. So the thing is, you said sati is being abolished. Is this really abolished in India? I'm not sure.
Again, you're raising it.
And the part of this question is, what are the factors influence sati to be abolished?
So we'll have to put an end to the questions sometime, huh? Because otherwise it'll go on. How long are you going to go on with the questions?
You tell me another 3 questions.
You've already got 2 in your hands. Yeah.
We'll take one more and
Yeah.
Good evening, ma'am. It's an honor to see you here. I'm a practicing lawyer myself, and my daily practice is family law and a lot of women law related stuff. Now, my everyday thing, what is my practical issues here is family law is an extremely vulnerable and emotional practice, and after a lot of debate with academicians in Muslim law especially, we can't keep Muslim law apart from the religion, especially because the law is centered around the Quran. Now, having said that, almost every Muslim person knows the law through the Quran. So there's a lot that I would want to get clarity from you, but keeping it short and sweet, why cannot the law be as objective as it is meant to be, rather than revolve around all the caste, creed, etc., etc.?
Lena.
I don't know what her question is.
Madam, what is this Muslim personal law? What is its constitution? How are they functioning, collecting all the money and posing as if they are the sole authority on Sharia and on Muslim law? Why are all scholars and jurists of Muslim law like Tahir Mahmood, like Asghar Ali Engineer, like Arif Muhammad Khan, like various other people, why are they completely ignored? Why are these neem mullahs? Half of them do not even have a proper degree. My dad was a Maulana, so I am a Maulana. My Dada was a Mufti, so I am a Mufti. My Pardada was a Qadi, so I am a Qadi.
Please allow him to speak. Please allow him to speak.
Why do you offend? Ask them questions.
Please allow him to speak.
My Dada was a Qadi, so I am a Qadi. My Pardada was a Mufti, so I am a Mufti. And how does anyone become a Maulana by heredity? Who are these people? How are they functioning? Why are they allowed to interfere? Why are they given any quarter whatsoever?
Last question, this lady was.
एक सवाल मैम, अभी जब हम जेंडर इक्वलिटी की बात करते हैं, औरत और मर्द के दोनों के मसावी हुकूक है कहते हैं, लेकिन शादी से पहले हम लड़कियों को ये कंडीशंस नहीं दिखाई जाती है कि इसमें औरत के क्या हुकूक है और मर्द के क्या हुकूक है। जब हम स्टडी करते हैं शादी के बाद में, तो इसमें औरत और मर्द के दोनों के हुकूक बराबर नहीं होते हैं, अलग अलग होते हैं। तो क्या ये सुप्रीम कोर्ट इस बात की हमें दलील दे सकता है कि इसमें क्या जेंडर इक्वलिटी है? क्या हम लड़कियों को हक नहीं है कि इसमें हमारे कंडीशन को भी लिखवाया जाए? और दूसरा ये है कि जब निकाह के लिए लड़की की मर्जी ली जाती है कि क्या उसे ये निकाह फलां बिनते फलां से कबूल है, तो फिर तलाक के वक्त में लड़कियों की इसके अंदर मर्जी को क्यों नहीं दिया जाता है? तो क्या ये हमारे मुल्क की जेंडर इक्वलिटी है?
Oh, okay.